Hey folks, we have a really special treat for you today here at the Four Boxes Diner. We are going to be working together to break history here on YouTube. Specifically, for the first time that I can tell on any Second Amendment related YouTube channel, we are going to be hosting and talking with a sitting federal judge. And it's not just any sitting federal judge we're going to be talking with today. It's Judge Amul Thapar of the Sixth Circuit Court of Appeals. You see, throughout his career, Judge Thapar has distinguished himself as an intellectual giant and a fierce defender of the founders' original conception of those rights enshrined in the United States Constitution. Judge Thapar has actually been on the short list to sit on the United States Supreme Court on multiple occasions. He was personally interviewed by President Donald J. Trump to potentially fill the seats of Ultimate Justice Neil Gorsuch, Justice Brett Kavanaugh, and yes, Justice Amy Coney Barrett. And the future, we'll see what happens in the future. But either way, no matter what happens, Judge Thapar is an important intellectual giant and figure when it comes to our United States Constitution. And he just published a book on Justice Clarence Thomas, the author of Usurper versus Bruin. And we're extremely lucky to have Judge Thapar join us here today at the Four Boxes Diner. And I hope you enjoyed this episode as much as I did producing it for you. I could not be more thrilled today and excited to talk to our guest here on the Four Boxes Diner. Judge Amul Thapar of the United States Court of Appeals for the Sixth Circuit is going to be talking about his brand new book, The People's Justice, Clarence Thomas, and the Constitutional Stories That Define Him. Judge Thapar is a judge on the United States Court of Appeals for the Sixth Circuit. He grew up in Toledo, Ohio. He graduated from Boston College and the University of California at Berkeley Law School. Before he served on the Sixth Circuit Court of Appeals, he was a federal trial judge, and before that, a federal prosecutor, so he knows a lot about the insides of the justice system. He's the best person to talk to on this topic, and I just want to say one thing before we turn to Judge Thapar and his book specifically. When President Donald Trump became the President of the United States, he nominated first and foremost Neil Gorsuch to the United States Supreme Court, and the second judge he nominated to the federal bench, specifically to the Court of Appeals, was Judge Thapar. So Judge Thapar is in high and great standing, a serious intellectual and a famous, well-known, respected judge. Judge Thapar, welcome to the Four Boxes Diner. We're thrilled to have you here to talk about your new book, The People's Justice.
Mark, I'm glad that's recorded because I'm going to play it for my wife, and then we'll see if we'll get an honest opinion from her.
That's right. And if she'd like, we're happy to have her on to give a rebuttal.
Yeah, that's right. She may want to do that.
Well, look, Judge, just to begin with, he wrote this book, The People's Justice, Clarence Thomas and the Constitutional Stories That Define Him. And I think we can agree that Clarence Thomas represents many important things in American life, but from a legal point of view, probably his most important contribution, in addition to just being a forceful, powerful personality, is, his views on how to interpret the United States Constitution, this notion of originalism. Can you tell us a little bit about Clarence Thomas and this notion of originalism, what it means, and why should the people watching this care about this notion in your book and generally?
Yeah, Mark. So I think originalism first and foremost, and if I can, I'll take a step back because I think originalism is about honoring the will of the people. But my step back is to Justice Scalia. So Justice Scalia really was the first justice to openly, of course, originalism is known since the beginning of our country, and we'll talk about that in a minute. But Justice Scalia is really the one who brought it back in vogue, and he should be given credit for that. And he said to all of us that we have an obligation to fly the flag, meaning that the academies weren't going to do it for us, the media wasn't necessarily going to do it for us, and so he thought it was our obligation to get out there and talk about originalism. And this book is a reflection, hopefully, of that. But it's also something much deeper, and I think all of us may or may not, we're either criticized for being originalist or we get credit for being originalist, but the reality is that originalism existed since the founding, and I hope your listeners and viewers will go back and look at what the Anti-Federalists said, and Brutus in particular talked about the original meaning of the Constitution and how judges could interpret the document consistent with the terms and concepts therein And if they didn't, and instead interpreted it consistent with what he called the spirit of the Constitution, what would soon happen is they would not feel bound by the document itself, and ultimately even by God. And so that's where originalism came from. If you look at the dialogue between Brutus and Hamilton, you'll first and foremost see originalism. So why then does Scalia and then Thomas and then a lot of judges like me become originalists? A, because we want to honor the will of the American people. It's the American people, not the unelected judges, who get to say what the law is. They do it through their elected representatives often, or through the Constitution and the amendments thereto. And it's important, if we want to remain a republic, I believe, and originalists like me believe, if we want to remain a republic and not a monarchy run by the courts, that we honor that will of the people and honor the document that they have approved and blessed us with taking care of and shepherding.
Now, when you talk about originalism and the will of the people, it seems to me, Judge, that really arguably the best evidence of the will of the people in any respect is what they wrote down and what they ultimately agreed and passed, enacted, ratified, whatever you want to say. It's the words that seem to really reflect at the end of the day what people understood they were doing. What are your thoughts on the role of text in the notion of originalism? What does Clarence Thomas think about that when he writes his opinions as a Supreme Court justice?
I'll tell you what we both think is original public meaning originalists. You've just so nicely talked about what it is, but the people listening to us and watching us are hearing our words and interpreting them. That's how they know what we mean when we talk. So the best example I give is when I got nominated to the Sixth Circuit. I was a district judge for a long time. When I got nominated to the Sixth Circuit, my neighbor came running down because he read in the paper I was an originalist, and he said, "Amul, I can't believe you're one of those. You're an originalist?" And I said, "Mike, you're a businessman, right?" And he said, "Yeah, I'm a businessman." I said, "You sign contracts as part of that business?" He said, "Of course I do." I said, "So if you and one of your clients has a disagreement about that contract, do you want me to interpret the words of the contract as you and he understood it? Or do you want me to look at it, tell you what I think should be in it, and tell you what's best for you?" And he said, "Of course you should interpret the contract and the words in the contract as we intended them to be meant and as they were meant when signed." And I said, "Mike, you're an originalist too now." And that's all it is. I mean, when people get all fired up about originalism, all we're doing is, remember, we took an oath. The Constitution provides that we take an oath to this Constitution. What does that mean? That means that those, to quote Randy Barnett, those who govern, the Constitution is the document that binds those who govern us. In other words, the American government takes an oath to this Constitution. The words and the interpretation of the words are all we're blessed with interpreting.
Yeah, and that's a great point. So that gets a little bit, and we talk about text, but there's also this discussion when you talk about originalism, and Justice Thomas is very powerful on this point. Sometimes to understand the text, one has to refer to the history. And obviously, it seems to me that the relevant history to understand what a text means is the history of understanding of the words at the time the text was adopted. No different, like you said, in a business contract. If we enter into a contract today, we have a specific understanding of those words and contemporary meaning. So it seems to be history plays a major role in the notion of originalism. Is that true? And would Clarence Thomas agree with that as a justice?
That's absolutely true. And I think the book, The People's Justice, demonstrates that chapter after chapter. And I think people will be surprised by what they find. Even people that are his most ardent supporters will, I think, be enlightened by the book. But I think the thing the book does best, hopefully, and you can be the judge, Mark, of that, is it captures Justice Thomas's view of how critical history is to understanding the terms in the document. The lead up, the history that leads up to the enactment can help us better understand the words and concepts contained in the Constitution. Just as a quick aside, the reason I keep saying concepts is the separation of powers, as we often talk about, is a concept. It doesn't say separation of powers in the Constitution. It has Article 1, 2, and 3 ascribing the different powers of government to the different branches. And so that is we use affectionately the term separation of powers. That is the concept that comes from those three articles and giving specific powers to specific branches.
Well, Judge, let me ask you this. In The People's Justice, this great new book, I've read, about half of it already, a bunch of the chapters, the intro and all that. Wonderful book. I highly recommend The People's Justice, Clarence Thomas and the Constitutional Stories That Defied Him. And I think it's a great title, by the way, Judge. He really is the people's justice because he so often stands up for really the individual over the greatest power of them all, which is the government and other powerful interests, which, again, is not necessarily his job per se. His job is to follow the law. And I think Justice Thomas really earnestly tries to do that, even when the questions are tough. And a lot of judges have to deal with tough questions. There are debatable points where even Justice Scalia and Justice Thomas would possibly disagree on certain things. It does happen because, again, if you could just plug in the question and have a computer spit out the answer, it might be a lot easier. But that's not the world in which we now live. I guess the question I have for you, Judge, is this. When people come up and say originalism is not a good way to do it, there's better ways of doing it, what are some of these alternative approaches to interpreting and applying the United States Constitution? And why do you think originalism, and why would Clarence Thomas think originalism is really the proper way to interpret the Constitution as opposed to some of these other notions like the living Constitution, for example, we hear talked about quite a bit?
Yeah, I think it's to go back to Brutus and to look at the document itself and what the Constitution vested the courts with. They didn't vest us with legislating. They didn't vest us. It would be ironic, right, if they included, everyone says, oh, amending the Constitution is so difficult. It would be really interesting if they made amending the Constitution difficult, but then they created a living Constitution that one district judge or 2 Court of Appeals judges or 5 Supreme Court justices could amend in an opinion. And so to the extent they say the document is living and breathing, first, it's really hard to understand how I am supposed to divine that living and breathing. And they say, well, consistent with today's standards of society. And what I always say, I go around and talk about this. I talk about originalism often. And people say, well, you sound pretty rational, Judge Thapar. Why not? Why shouldn't we let you decide? You sound better than a lot of people. What I always say is, why don't you talk to my kids and see what it's like to live in my America? Because that's a lot different than what people have today under the original meaning of the document. So, and the other thing is, the original meaning is constraining. People say, at the end of the day, it's who do you trust? Do you trust unelected judges or do you trust the American people? Because as Justice Scalia said, when dealing with the difficult issues of today that aren't provided for in the Constitution, so aren't clear from the original meaning of the Constitution, he himself said, and he was kind of tongue-in-cheek, but what he meant, he said, I trust 9 people randomly chosen out of the phone book over the 9 of us in this building. What he meant is he trusts the American people. Originalism at its core is about trusting the American people. And people say, well, amending the Constitution, I'm sorry to ramble on, but amending the Constitution is difficult. Well, you don't have to amend the Constitution. Go convince your neighbor. You can get it in your city council. You can get your state to do it. You can get the federal government to do it through laws. Convince your neighbors. That's what we used to be about. That's what the fabric of this country is built on. And I think we'll all get along better if we don't keep resorting to the courts to solve all our problems.
Now, there's some discussion about, originalism, and I think one of the pushbacks that you read about, mostly in op-eds, to some degree, it does slip into various opinions in court opinions. But there's this sort of this notion that, the Constitution and its separation of powers, the federalism system of states, and all these sorts of things, really, this is kind of a form of a tyranny of the minority. I hear that in the popular press, a tyranny of the minority, because we can't just have 51% of the people vote to steal the property of the other 49%. But as I recall from my history about as an originalist in the Federalist Papers, the Anti-Federalist Papers, there was real concern about mob rule and how to balance protecting fundamental individual rights against, necessary government powers to protect those rights from, for example, foreign invaders. So how did, at the time of the founding, the founders balance that out? What were their concerns and considerations about individual rights versus governmental powers? And of course, individuals have rights and governments have powers and authority. And Justice Thomas, in the opinions we'll get to in just a second, talks quite a bit about this notion. So what's your reaction to that? And what do you think the founders are trying to accomplish here, Judge Thapar?
Yeah, I think if you remember, and you just, again, referenced, I think it's important, we don't do enough reading about the Anti-Federalists. And, a lot of people say, well, the Anti-Federalists were the losers. Well, what I would point out is the Bill of Rights is here because of the Anti-Federalists, because they were so concerned, right? What they didn't want to do is replace one monarch with another. So they created a limited federal government, the founders did. And in doing so, the American people were your God-given rights. You were allowing some infringement on that in a limited way by the federal government. That's what the Constitution reflects, and everything else is retained to the people. But the Anti-Federalists wanted specific rights enshrined in there, and that's where the Bill of Rights comes from, is their demand that the Constitution not be passed alone, but that a Bill of Rights be included, and James Madison promised he would include that Bill of Rights. And that is the thing that is the stopgap against government and other government entities intruding on your rights. And then everything else is retained to the people, remember, and we can, through working with our neighbors, pass local laws or state laws or federal laws to accomplish other things.
In reading through your excellent new book, The People's Justice, Clarence Thomas and the Constitutional Stories That Define Him, there's one of the things I've noticed in the People's Justice book that you just published, Judge, is really this discussion of sort of pre-existing rights. I mean, you see this in the Kelo case dealing with the right to private property, which, of course, is an extension of one's labor. The McDonald case, which, of course, deals with the right to self-defense, the Second Amendment right to keep and bear arms, and several other cases that dealing with these kind of really fundamental individual rights, fundamental human rights in many respects. And I'm just curious, what exactly, people often say, well, what are these pre-existing rights? The Supreme Court talks about that the Bill of Rights embraced, codified pre-existing rights. They didn't actually create rights. They really memorialized or codified rights that the founders thought we all just had. What's the story with that dynamic there? And what does Justice Thomas say? And what do you glean from what he says from all of the opinions that you've read to write your book, The People's Justice?
Yeah, and maybe one way to do it and explain it is to talk about McDonald's, since you brought that up. And I think that's a nice chapter that gets at what you're talking about. And so Otis McDonald, and can I give a couple minute background?
Yes, you should definitely. Otis McDonald, it's a fantastic story that you tell in your book, and I think it really speaks to the whole book. I think it's a great example. So go right ahead, Judge.
So Otis McDonald is this great American. At a young age, he moves from New Orleans to Chicago. And he comes to Chicago to pursue a better life. When he gets there, he decides to sign up for the military. He serves our country. He enlists in the Army and gets out as a vet and on the GI Bill. And during the day, he's a janitor. At night, he's going to school. Pursue a better life for him and his family. And as he does better, as he graduates and gets better jobs and becomes the head of his union, he moves his family, his wife and his 3 kids, to a community known as Morgan Park. And Morgan Park at the time was a safe community where he felt like he could raise his kids. All he wanted to do is give his kids a better life than he had. And the chapter recounts how slowly gangs and crime crept into his neighborhood. And as a result, he suffered 6 different crimes, and the chapter goes through the crimes he suffered. What did he do in response? First, he put bars on his windows to try and keep criminals out. Then he put an alarm system in. When all that didn't work, he joined a community group that worked with the police to keep the neighborhood safe. He then became the head of the community group. None of that stopped the crime from occurring. And one day, when a neighbor saw someone who had broken into his house, luckily an eagle-eyed neighbor spotted them hiding under his car in his garage. They called the police. But what Otis knew is next time it could be too late. If someone's in his house and he calls the police, God forbid they do something, because the police won't get there in time. So Otis wanted the right to possess a pistol. And he asked Chicago to be able, this vet, this college graduate, this person who made something of himself, all he wanted to do was protect his family, have a gun, a pistol at his bedside, and Chicago said no. So now he approaches the Second Amendment Foundation, and they hook him up with a lawyer, Alan Gura. And Alan's got a case called Heller that's in the District of Columbia that was arguing that we should restore the Second Amendment to its original meaning. And he won that case, as we all know, and Justice Scalia wrote the opinion for the Supreme Court. Well, the chapter recounts the drama. I'll let your viewers get the book and see the drama, but what happens is this case Otis's case eventually gets filed and makes its way to the Supreme Court because this Heller case was involving the District of Columbia. The Second Amendment applies to the federal government. So how are our constitutional rights, meaning the Bill of Rights, applied to the states? Well, traditionally they were applied through substantive due process. But that, as Justice Scalia famously remarked, was made up. There's no substance to process. It's a procedural thing. And so Justice Thomas, the decision comes out, and Otis McDonald, the grandson of slaves, feels like he's vindicating rights long forgotten for Black Americans and all Americans. Now, why is the Black American point important? Because what Justice Thomas traces in his concurrence, it's a 4-1-4 decision where Justice Thomas is the one, and he provides the deciding vote to the majority to vindicate Otis McDonald's right to possess a firearm. But he does so by interpreting the Privileges or Immunities Clause of citizenship. And why does he point to the Privileges or Immunities Clause? Because he studies the history, and he understands that after the Civil War, the South and other states were using what were called black codes to make sure blacks didn't have guns. In fact, after the Civil War, they would forcibly take blacks' guns. 180,000 freedmen were not allowed to possess a firearm, and I'm quoting Justice Thomas when he talked about that in the chapter. And he talks about all this, and he talks about how Frederick Douglass said that blacks would never have equality if they didn't have the right to possess a firearm. And he traces all that, the history as to why the Privileges or Immunities Clause was put in the 14th Amendment. It was put in the 14th Amendment, among other things, to secure blacks' rights to possess a firearm. Sorry to go on so long.
No, it's very important. Continue on, please.
So after that, the one thing, and then I'll let you ask me questions, but the one thing I wanted to say is, here is the descendant of slaves rectifying what he believed. And Otis, the book recounts how Otis studied this stuff and read and was a very well-read person, but rectifying this injustice. And it was the descendant of slaves, Clarence Thomas, writing the opinion that talked about it in the Privileges or Immunities Clause of citizenship. So why did he write alone? Because, and I won't get into this in detail, but there were a line of cases where basically the Privileges or Immunities Clause was read out of the 14th Amendment. And Justice Thomas recounts those, and the chapter recounts those, known as the Slaughterhouse cases and others. And I think people will be surprised by the facts of many of those cases and how it continues to be read out of the Constitution. But Justice Thomas believes every word in the Constitution has to have meaning, and he looks to the text in history, and this chapter demonstrates it as well as any other.
You know, just the part, since we're talking about Clarence Thomas here, because of course he is the focus of your book, The People's Justice, you know, it really is interesting if you look at the history of Clarence Thomas's work on the Supreme Court, how so many times he sort of has flagged an issue in a footnote, in a concurrence, in a dissent from cert. He flags an issue, say, you know, down the road, we, the Supreme Court, may need to revisit this or think about this a little harder than we have been. And he's done this repeatedly. And there's many instances where it turns out that passing footnote he makes ultimately becomes the view of the U.S. Supreme Court. And he's done that repeatedly. And I think that you're right. The McDonald case dealing with the Second Amendment, which is really a restoration of a right that was always there in the text of the Constitution, I think that's a great example of where he's flagged something and ultimately goes to. And of course, I think that privileges and immunities issue is another one where he flagged right there, which is a subject to much debate as to the notion of a substantive due process and that oxymoronic concept, which we've been using for so many decades. But where do you think, are there other examples, or we talk about Clarence Thomas as an independent intellectual thinker, but are there examples in your mind of where he's kind of led others? People have said, well, Justice Thomas really has it right, and he's kind of moved forward and moved a body of law in a particular direction that's honest and favorable to the notion of originalism?
I mean, I think there's a lot of areas. Some will surprise even your viewers. So he's got a case that I reference in the end of the book that involves mandatory minimums for criminal punishment, and he traces back what jury trials did historically and how juries were involved in sentencing. And so now, as a result, prosecutors, and I won't go into the details, but prosecutors have to prove to a jury a certain minimal level of conduct before a mandatory minimum can be imposed. That was Justice Thomas. Well, he was flagging that long ago. And it's an interesting area because people say, as I trace in the introduction, they say he's the cruelest justice. They say he's stupid. They say he's an Uncle Tom and a traitor to his race. And this book, in every chapter, proves the opposite is true. The other area he's been flagging, and he shows how getting away from the original meaning has unintended consequences. And I think, Mark, one of the chapters people will really find interesting is what I call Beauty and the Beast, but the McKee versus Cosby chapter, Bill Cosby. They'll be surprised to find who was on the side of victims in this case and stood alone, and constantly, just in the last week of the term, he's never forgotten Kathy McKee, and the book talks about Kathy McKee. She was one of the alleged victims of Bill Cosby. Cosby and his lawyers then smeared her, and what stood in her way to proving and vindicating her good name in court? It was a case called New York Times versus Sullivan. Well, as you know, Mark, Justice Thomas has been talking about this constantly, and every time it comes to the Supreme Court, he writes separately, interestingly enough, or most times, to point out the unintended consequences where the Southern Poverty Law Center, a church, had believed they were unfairly smeared, and it cost them a lot of money in donations and otherwise by the Southern Poverty Law Center. They wanted to vindicate their name. All of these people are stopped by this case. Why are they stopped by this case, New York Times v. Sullivan? Because its doctrine has become such that when you accuse someone and I'm quoting Justice Thomas, a powerful man of rape, you then become what's called a limited public figure. And again, to quote Justice Thomas, it's almost impossible to have your day in court because you have to show they actually, whatever they were saying, they actually knew. And how do you prove or reckless disregard for the truth? And this standard in court is incredibly high and difficult to meet.
You know, Judge Thapar, there's definitely notions, and even Justice Roberts in oral arguments made references, for example, these kind of barnacles on the Constitution that have been developed. Really, you know, you can debate when this starts, but, you know, you could argue from, you know, the 30s all the way up to the 80s. Sometimes you can start in the 50s. It sort of depends on the body of law, but these sort of barnacles on the notion of what the Constitution means. You're right, New York Times versus Sullivan, the notion of tiers of scrutiny, which is really just a balancing test. Yeah, the government's violating your fundamental rights in the Bill of Rights, but we still get to balance it away if the interest is important enough to the government. So you got these barnacles on there, and you used a very powerful word, and I like to understand how you might solve for this. You used the very powerful word of restoration, or to restore the Constitution to its original meaning, to its original understanding. And how does one do that in a practical world where you have decades of sort of precedents and whatnot that, you know, have built up as barnacles, as Justice Roberts might refer to them?
Yeah, I mean, I think that it starts with the lawyers and the people. I think the American people and lawyers, the more they understand the original meaning, the more they can bring it in briefs. There's areas where the courts and lower courts can flag them for the Supreme Court, but ultimately it is the Supreme Court. And then, as you know, and it's for a different day, we can discuss stare decisis and the different views of stare decisis, and there's some originalist arguments in support of stare decisis that smart people like McGinnis and Rappaport are making, who have an originalism blog, and it's a very thoughtful blog, and they have those arguments. Justice Thomas contrary to them, believes that the Constitution is supreme. It's the supreme law of the land. And when it's clear, and he just recently wrote about this in a case called Gamble, when it's clear that the Constitution, what the original meaning of the Constitution, the law is inconsistent with it, we have an obligation in his mind to overrule the law. And McDonald was a perfect example of that, where Justice Scalia was saying, Justice Scalia always called himself a faint-hearted originalist, I think unfairly, but one way he thought he was faint-hearted was stare decisis versus Justice Thomas, who he always said was pure in that regard. And that's why Justice Scalia signed on to the majority in McDonald and not on to Justice Thomas's opinion, because he believed it was water under the bridge, and at this point we were stuck with it. And I think he had other concerns as well, but the reality is that these are the areas where Justice Thomas and Justice Scalia have parted, and it often revolves around stare decisis.
Yeah, you bring up an excellent point. I mean, in the early years of Justice Thomas's term on the Supreme Court, there was a lot of talk in the press, of course, about how Clarence Thomas just went along with whatever Justice Scalia did, things like that. But for anyone that's a real observer of the courts, I think that Justice Thomas and Justice Scalia were very similar. But boy, I think it's hard to say that Clarence Thomas was following along Antonin Scalia and not necessarily the reverse. Do you have any thoughts on the dynamic between the jurisprudence of Justice Thomas on the one hand and Justice Scalia, of the similarities and maybe the dissimilarities there when it comes to originalism?
Yeah, can I say one point on that, Mark? Because I think when Justice Thomas first came on the bench, everyone, and I don't know if it's racism or what, but everyone derogatorily accused him of being a clone of Scalia. And Justice Scalia immediately corrected that, and most of the justices on the court at the time, in fact, all of them at some point have said, no, Justice Thomas, in his very first sitting, was going to write 3 solo dissents that eventually garnered other votes. And so Justice Thomas, from the very beginning, has truly believed that he is what I would call a pure originalist. In other words, he's never going to let his personal views trump those of the American people in his own mind, nor is he going to let any doctrine he believes is not mandated by the Constitution stand in the way of restoring the original meaning of the Constitution. Why does he believe that so much, if I can say for a second? I think it's his background. I think it's my background. This is one thing I trace. So originally I was going to write a book that was meant to just explain originalism, fly the flag, as I said at the beginning of our conversation. And what I realized in studying the original meaning, studying Scalia and Thomas, I used to teach a class called Scalia versus Thomas, is that while originalism can take many different forms, Justice Thomas's originalism recognizes the popular sovereignty of the American people. And it recognizes that the American people ultimately hold the power, not their government, not their judges. Now, why is that so important? Because Justice Thomas came from nothing. He grew up in the segregated South. His mom made $10 a week and couldn't afford to raise her 2 boys, so she gave them to her grandfather. And every time he or his brother would complain they can't do something, his grandfather would say, "Old man Kant is dead. You know how I know? I helped bury him." And his point was, work hard, do your best, and good things will happen. The one thing his grandfather understood, and chapter 2 of the book traces this to Justice Thomas's jurisprudence, is education means emancipation. To quote Frederick Douglass, Justice Thomas does it. And it's that to get out of the dirt, being literally dirt poor, and education would do it. And he saved every penny he had to send a young Clarence and his brother to Catholic schools. And Justice Thomas credits this with his foundation that ultimately resulted in him being so educated, finishing 9th in his class at Holy Cross in the entire school, in his college. So that's what he traces. How do I get to originalism? My dad came here. My dad was so poor in India. Why was he so poor? Because his dad died at 2 years old. And back then, being a single mom in India was incredibly difficult. And he came here with a one-way ticket and a $5 bill. That's what his mom could save up to get him out and said, go make something of yourself. And then as my sister and I would complain, he would always say, this is the greatest country in the world. If you can't accomplish it in America, you can't accomplish it anywhere. Both of us grow up, and think about it. I come as the child of immigrants. I watched my parents be naturalized, And now I naturalize people. Imagine that. And Justice Thomas came from being literally dirt poor, single mom, making $10 a week in segregated Georgia to the highest court in the land. I'm on the U.S. Court of Appeals. Who do we have to thank for this? The American people. So people say originalism favors the rich over the poor, the strong over the weak, the corporation over the consumer, the government over the individual. The stories of the cases, as recounted in the book, prove the opposite is true. It proves that originalism at its core favors the American people.
Yeah, I mean, one theme that runs throughout your book, and I can tell that you're telling it with great emotion, the People's Justice, Judge Thapar, is how Justice Thomas really does feel, even though he's applying the law, he's doing his job as he's supposed to, he really does have a sense and feel for ordinary Americans and their, the things they have to face, the good and the bad of living. We all have good and bad and good times and bad times. And Justice Thomas, I think, really understands that so much more than some other people that work in government. And of course, judges do, in a sense, work for government, right? They're part of the three branches of government. And I think, I think one of the great, and this goes to Justice Thomas sort of forecasting where things go down the road. I think, and I don't think you put this in the book, but I'm sure this will be in your next book on Justice Thomas, a little paragraph he wrote in a dissent from certiorari in the Peruta case, which is really a case that ultimately down the road became the Bruin decision that Justice Thomas wrote on the Second Amendment just in 2022. And I think when Justice Thomas wrote this, it's so powerful. I think it does speak to the people's justice notion when he wrote, and this is what he writes, quote, "For those of us who work in marbled halls guarded constantly by a vigilant and dedicated police force, the guarantees of the Second Amendment might seem antiquated and superfluous, but the framers made a clear choice. They reserved to all Americans the right to bear arms for self-defense. I do not think we should stand idly by while state, that's the government, denies its citizens that right, particularly when their very lives may depend upon it. I respectfully dissent." That's period, close quote. Justice Thomas dissenting from the denial of cert in Peruta, which again, that same question presented ultimately came up in Bruin, and Justice Thomas not only was vindicated, he actually wrote the opinion. And I think there's many other examples. So before we wrap up, Judge Thapar, are there other examples that you'd like to flag in addition to all the things in your book, anything in it that you would like potential readers to understand that really shows that Justice Thomas is the people's justice in the real world, even though he sits on the highest court in the land?
So I'm not going to get into it now, but I do want to, I grabbed the book. I want to read a quote from it because it goes right off what you said, Mark. It's so great that you read that, because in the chapter leading into the McDonald chapter is Morales versus City of Chicago. So two Chicago cases. In Morales, the people of Chicago are trying to keep gangs off their street corners so they can go outside and be safe. And when people read it, they're going to be mortified about the history that led up to the passing of this ordinance, which was an anti-loitering ordinance, which meant gangs couldn't loiter on street corners because they were protecting them with mortal gunfire, their turf. And here's what Justice Thomas writes in his dissent when they strike down the loitering ordinance. And I think once your readers read the chapter, they're going to be amazed at your listeners and viewers, I'm sorry. But here's what he says that goes right off your paragraph that you just read. "Today, the court focuses extensively on the rights of gang members and their companions. It can safely do so. The people who will have to live with the consequences of today's opinion do not live in our neighborhoods." The same thing, he's saying, look, we live in these fancy neighborhoods. We don't have to worry about gangs. And he really, just captures in opinion after opinion. He's always an originalist first and foremost. You see that throughout the book. You see it in his criminal justice jurisprudence where he rules for a criminal defendant because the Constitution compels him to. As Justice Scalia said, look, no one's going to accuse Justice Scalia of being in favor of criminals. Right? But when he rules in favor of criminals, it's because he has to. One final Scalia quote is Scalia said, "If you always like the result you reach, you're not being a judge, you're being a politician." And it's important that judges remember that you're not going to get everything you want when you follow the original meaning of the document. you're not going to get probably half of what you don't want, but you are going to, what Justice Thomas never fails to do, you captured it there, Morales captures it, is he talks about how when we get away from the original meaning of the document, it often harms those that can least afford to be harmed, the most vulnerable amongst us. Why? Because the document, after all, is meant to protect them. It's not meant to protect the rich and powerful, although it will by default, but it's really meant to protect the individual, the little guy. People like my dad that come here because they can trust the rule of law, meaning what it's intended to mean, not what some powerful judge or some rich person thinks it should mean.
And that's what makes the United States so special. It really is the rule of law and not the rule of men in that sense. And I think that is one of the great successes of the founding generation that gave us this U.S. Constitution and our Bill of Rights. So, Judge Thapar, as we wrap up here, is there any, if people ask, well, why should I'm interested in the Constitution, I'm interested in the Bill of Rights, I'm interested in the law, I'm interested in Clarence Thomas, who I read about every day in the paper, sometimes is critical stuff on Clarence Thomas. Why should I read this book? What am I going to get out of it? What would you say to them?
I think they're going to be fascinated by it. I think they're going to get a walk through history because, as you said, Justice Thomas is going to give you a walk through history, but you're also going to read the stories and the grapples of the real people like Warwick Dunn, the famous NFL running back that had to pick up the pieces for his family after his mother was brutally murdered, and it traces Warwick Dunn's championship life against the killers. And you'll see firsthand how Justice Thomas talks about the original meaning, talks about what the Constitution and laws mean, and also how it champions the little guy. The other thing I think it's going to do, it's going to give all of your viewers ammunition. When people are, whether it's at a cocktail party or around a keg, at a barbecue or a picnic, people are going to be derogatory towards Clarence Thomas because of what they read. They can correct those misperceptions. Better yet, they can encourage their friends to get the book and have discussions with them about it. I think that's how we're going to change, one heart, one mind at a time. And I think people are going to be surprised by the contents of the book and how it's going to walk people to have a different view of Clarence Thomas, especially as critics.
Yes, I could not agree more. And Judge Thapar, thank you for joining us. I just want to say one thing. You mentioned several times the abolitionist Frederick Douglass from the late 19th century, who Justice Thomas refers to on several occasions in many of his opinions. And I just want to mention that you're here on the Four Boxes Diner, which is inspired by Frederick Douglass, because Frederick Douglass talks about the boxes of American liberty, that one needs to be a citizen and not a subject or a serf. And those four boxes, of course, are the soap box, the jury box, the ballot box, and the cartridge box. So we here at the Four Boxes Diner take the words of Frederick Douglass very seriously, as we do the words of Clarence Thomas, and of course now the words of Judge Thapar. So Judge Thapar, thank you so much for coming. I know the audience is going to love listening to this and checking out your new book, The People's Justice, Clarence Thomas, and the constitutional stories that define him. I cannot think of a better subject to learn about originalism and American law. And thank you again for joining us. And I'm sure we'll see you again soon. And again, thank you. It's been an honor.
Thank you.
Orders up. Table 2A.